Elder law attorney. I have been with Hickman and Lauder, like Patrice said, for about 2 weeks now, but I've been doing elder law and asset protection for the last 5 years. This is all very old hat for me, and I understand that folks have seen this presentation maybe once or twice before. So I am going to kind of hit the high points and go through it pretty quickly. And then my hope was to have a question and answer session once we're all done, because I'm sure that you've been thinking about this, you've been coming back to it. So I think now might be a good time to maybe clear up some things and answer some of the questions that you have. But let's go through the PowerPoint first and kind of hit the high points about what we're talking about, and we'll get started. So the first thing that you need to think about when you are thinking about protecting assets is whether you are going to need long-term care within the next 5 years. The reason for that is when someone applies for long-term care Medicaid, the Medicaid caseworker will go over the past 5 years of that person's financial history. And if they've done anything to protect assets in the last 5 years, that results in a penalty period where if you've gifted money or you've given things away, even though you're eligible for Medicaid, you have to wait until your long-term care payments are paid for. So if you are starting to think about this, the first thing you want to think about is whether you are going to make that 5-year period or not. Because if you're not going to need it for more than 5 years, you can do whatever you need to do, put things in trusts, protect things, gift things, and it's never going to be an issue for Medicaid if you get past that 5 years. Now, if you're not going to get 5 years or you have a crisis situation, then there's a little bit of different planning. But for 5-year planning, it's pretty straightforward. You put whatever it is that you want to protect and not have to spend down for Medicaid. You either gift it to somebody beforehand, or more likely you're going to put it into a special kind of trust, which will protect it from being counted as a Medicaid asset. So there are some exceptions to those penalty period and penalized transfers. So the caretaker child exception, if a adult child lives with one of their parents for 2 years in their home, then when the parent needs long-term care, they can transfer the ownership of that house to that child and not have a penalty. Now, there's a lot of paperwork involved in that. There's a lot of documentation that needs to be done, but that's the gist of it. So talking about the 5-year period, if you aren't going to make it 5 years, generally speaking, you can keep about half of what it is that you of your savings without having to spend it for Medicaid. There's some different strategies that you can use to pay for the care while you're on that penalty period. You can use a pooled trust. You can use a Medicaid annuity. The idea being you make transfers, you apply for Medicaid, you take that penalty period, and then you have done planning where you have a source of funds that are going to pay for care while you're waiting for that clock to run out. And then once the clock is up, you go on full Medicaid, and what you protected is protected free and clear. Another exemption is transferring assets to a disabled adult child. So anybody, even if they don't necessarily even have to have been disabled since their birth or since youth. Anybody under the age of 65 who has been determined disabled can qualify for this exemption. And you can either transfer things to them directly, or you can set up a trust that is specifically for that person's sole benefit trust. And those don't require Medicaid payback. So if you have somebody, a child who is disabled or on disability, you can take advantage of that exemption and protect assets for their benefit without having a penalty period. Married couples have an ability to protect just about all of their assets. The way that a married couple case works is if a spouse who needs long-term care has a healthy spouse who's still living in the community, that healthy spouse is entitled to the home, one car, and they get a resource allowance. It's up to $128,000. It's actually going to go up a little bit more in 2021. They adjust it every year, and they don't count that spouse's income, and that's really important. So one of the strategies for that situation, if a healthy spouse has a ill spouse in a nursing home, is to create a Medicaid annuity where that healthy spouse transfers resources into an annuity that then pays them back monthly payments, turns that into a stream of income. And so that is taken off of the table for Medicaid purposes, and the healthy spouse can keep really all of the resources above that $128,000 for their benefit. And it's a great situation because oftentimes you have spouses, a healthy spouse might live another 10, 20, 30 years, and $128,000 and your house and your car, that's not going to be a great quality of life if that's going to have to stretch for 30 years. So doing a Medicaid annuity it can be really, really valuable in those situations. So I know that Ethan went through the myths last time around, so I'll just hit them. I'll hit the high points here. The first and the biggest one, Medicaid does not want your house. The nursing home doesn't want your house. There are some situations where if a single person, for example, owns a home and goes into long-term care and has a home, eventually that home is going to be counted as a resource, and all things not doing any planning, that person would have to eventually sell their home or lose their Medicaid. The other misconception is with estate recovery. If somebody has been on Medicaid and when they pass away with a house still in their name, Medicaid would have a claim against that house for repayment, unless they still have a spouse or a sibling or somebody who relies on that home for their needs, in which case then Medicaid doesn't. So good planning can avoid estate recovery entirely. So the takeaway is Medicaid doesn't want your house. They really don't. Another myth is you have to spend everything down. Again, a community spouse, a healthy spouse, has a resource allowance. You can do other types of planning for protecting assets. You can put funds into certain kinds of trusts. So you can do other things. You have options other than spending everything down. Don't let them tell you you've got to spend everything down. You don't have to use your IRA. Again, you can convert it to an annuity. Not everything you own is countable. There's lots of exempt resources: a home, car, prepaid funerals, whatever the spouse is entitled to. All your stuff, your personal possessions, your clothing, your furniture, none of that is ever counted. So you can always take money that you have that is counted, and you can purchase these exempt things, and that's a way of reducing your resources to get Medicaid eligibility without having to spend it all on care. We talked about estate recovery. State of Ohio isn't going to take your house. They have a claim against it in very limited circumstances that planning can really avoid pretty easily. Okay, so planning for long-term care. So this is that 5-year plan. So married couple, John and Sue, they're 70, they're in good health, and they've got about $1.2 million total assets. They're going to do a 5-year plan. And so what they do they create a trust, and this trust has to have certain provisions in it. On paper, John and Sue have to give up control over what they put into that trust. So that trust is going to say things like, John and Sue are not beneficiaries of this trust. John and Sue are not entitled to change the trust. They aren't able to take anything back from the trust. It's a gift. And what Medicaid's going to do is, if they make it 5 years, they don't have to tell Medicaid about that trust because it's outside of the 5-year window. So what John and Sue do in our scenario here, they create one of these trusts, they put $700,000 into it. The beneficiaries of that trust are their children. So while they're alive, that money is going to be held in that trust. So if one of their kids gets in a car accident or has a medical bill or runs into any kind of issues, that money isn't on the table to be seized or be used for satisfying debt or anything like that. When the latter of John and Sue, when the second one of them passes away, is when the trust then distributes, just as an estate plan does. So they make it 8 years. Sue goes into the nursing home. They have about $500,000 remaining and their house and their car. So what they do is they take the amount above that community spouse allowance and they turn it into an annuity for John. He gets monthly payments as a stream of income, and Sue goes right on Medicaid and gets her long-term care paid for. She only uses her income to contribute for her long-term care costs, and John is protected. So not only does he have the resources to keep living, they've protected assets for their family as well. And I think we've got some questions coming up. I'm going to do a Q&A here at the end, so just hang on to them. Another example, I kind of touched on this earlier. This is the spousal annuity situation where they own a home. John has an IRA, it's $450,000. His wife goes into the nursing home. Now, if they do nothing, Medicaid is going to count that $450,000 as a resource, and they're going to say they need to reduce he needs to spend it before Medicaid will kick in. But what John does is, instead of spending it, he converts it into a Medicaid compliant annuity, which means that Medicaid no longer counts it for purposes of eligibility. He keeps receiving his payments, and Sue's able to go right into Medicaid directly. Care contracts. These are incredibly important, especially I think now, with COVID and the way things are changing, I think people are going to be looking more at trying to stay home and having care done. And it's a time-honored tradition where kids come back home and they take care of their parent. We touched on it earlier, where if the child actually moves into their parent's home and cares for them for 2 years, the home can be transferred directly to them. Another option is to do a care contract where the parent and the child, so in this case, Sue and Pam, they write up an agreement where Sue is going to pay Pam a monthly amount to take care of her. And Sue and Pam enter the contract. Sue pays her that $16 an hour. She gives her a payment every month, and Sue and Pam cares for mom. If they didn't have this care contract, Medicaid would look at that and say, well, Sue was giving Pam gifts every month, and so we're going to penalize that. But with a care contract, Medicaid is going to allow Sue to pay Pam those monthly payments and not penalize them. So that's the important reason for having that contract in place, is that Medicaid's not going to penalize Sue for paying for care, but they're going to look at it really closely when it's a family member who's giving that care. And so having that written care contract is a way to make sure that Medicaid doesn't penalize those payments to Pam for that care. So this is the typical crisis planning situation for a single person. So John has a stroke. He needs to go into a nursing home. He has $150,000 in a home, and he has $125,000 in investments. If John does nothing in this situation, he's going to go into the nursing home, and Medicaid is going to look at him as being over-resourced. He can keep his home off the table for about a year. But that $125,000, Medicaid's going to say, you gotta spend that, or until we get Medicaid, or until we will give you benefits. So in the normal course of events, John doesn't do any planning. He spends that $125,000 on his care, and then he goes on Medicaid. But eventually, Medicaid's going to make him sell the house as well, and so he's got to sell the house, get the $150,000, and then spend that on care as well, until eventually he has nothing left and he goes on Medicaid. So the strategy to avoid doing that is he gifts his home, he signs it over to his 2 kids, and that means Medicaid's going to penalize him 21 months for that transfer. What John does with the $125,000 then is he puts it into what's called a pooled trust. Pooled trusts they're a special kind of care fund. They're a trust that's held by a nonprofit group, and John can put that $125,000 into that pooled trust. It's not penalized, it's not counted for eligibility, and it can be used for anything that he would need. What John's plan is to use that $125,000 in the pooled trust along with his income to pay for the nursing home during that 21 months that he's going to have to private pay because he transferred his home. When the 21 months is over, John has gotten through his penalty period, his long-term care has been paid for in full, and he's able to go directly on long-term care Medicaid without any kind of additional private pay period. And he may have some money left in that pooled trust because the pooled trust will invest it, and that money may have grown. So if there's any money left over, it's bonus. He can use it for anything that he would like, even though he's still getting his Medicaid benefits. So the Medicaid application process. This is the part that really makes people pull their hair out because it is incredibly intensive. There's a lot of information that Medicaid needs to process these applications. They need 5 years of your financial history. They need a lot of documentation about your birth certificate, your social security card, a photo ID. They want to know about your other health insurance, so your Medicare, any Medicare supplement or advantage. They're going to look at what your income is. So they can look up your social security, but anything else that you would have, annuities or pensions or anything like that, you'll have to provide to them. The documents are submitted to the County Department of Job and Family Services. They're assigned to a caseworker. Some caseworkers are great and they're efficient and they're thorough and they get things right, and your application goes through pretty well. Some caseworkers aren't so great and they miss things, they aren't fast, they get things wrong, and at that point you're looking at having to go to either a state hearing or you're trying to get them to push things through. And if you don't do it a lot, like elder law attorneys do, the process can be pretty intimidating, and you may not even really know who to talk to, who to call. So it can be a really difficult kind of process to get these Medicaid applications through. And I have a lot of my own opinions about why that is, but that's for a different presentation. So oftentimes Medicaid will deny applications incorrectly. So for example, you submit all of your bank account information, but one of your bank accounts doesn't make it to the caseworker's desk, and they deny your application because you didn't provide this information. So you have to go to state hearing where you show that, yes, I did show them this bank account information. they did have it. I don't know why the caseworker didn't see it, but that's not your fault. And typically the Bureau of State Hearings will then overturn the denial, send it back to the caseworker and say, process this application. If for whatever reason the state hearing doesn't overturn it, you can appeal to the next level, which is administrative appeal. That's where the actual Ohio Department of Medicaid itself will look at your case and make a decision. And then if you're still not happy with that, you can then appeal into the regular court system. Those are pretty rare. It's only been a handful of times in my career that we've actually had to do that. But it can be done. You have full due process rights all the way up. You know, if necessary, you go to the state Supreme Court. So that was the quick and dirty run through of that. There's a lot more to talk about with all of those slides, but I think I'm going to stop the screen share now and open things up.